just bear with me. I've got a sound issue which I'm gonna deal with now. Coming up live now, folks. Just bear with me.
1, 2, 3, swing it.
Do you have an old sound tape or your favorite cassette tape that you want converted to CD or MP3 format? Do you need a demo CD, radio ad, a DJ or even a sound system for your wedding, birthday or special occasion? Then why not get in contact with KTR Records on 07931 152 448 or check out our website on www.ktrrecords.com. We have been in business since 2004 and also undertake community projects. So for your remixes, dubplates and all your sound editing needs, why not contact KTR Records, official sponsor of World Jam Global Radio. KTR Records, coming your way.
I was terrified about sharing the vulnerabilities of people with difficulties reading and spelling words. However, I can see the value in sharing, and I have taken the time to make some notes about this in my book, Dyslexic: The Silent Difference. You can get your copy now at www.a1tribe.com or amazon.com or amazon.co.uk. Thank you again, everyone, for your support.
Red Promotions and Highly Blessed Promotions give you Tobago 2020. Tobago 2020, the ultimate carnival experience. Landing on Sunday, 23rd of February 2020. The all-inclusive holiday of a lifetime at an unbeatable price, starting from £1,349 for 7 nights, all-inclusive, with 10 nights optional. There will be fun-filled day and night events like the popular all-white party, pool party, barbecue boat ride, plus the carnival experience and much more. Music by some of London's finest, Courtney Melody, Commander B, D-Mac, TC Fords, DJ Matt and Euro Millions and more. So join us and let's live our best lives. For general inquiries, call 07729 190 026. For booking and more info, call SN Travel on 0207 254 0136. Quoting Tobago 2020. Sponsored by VibesFM.net, MrMighty.co.uk, SN Travel and
World Jam Global.
Do you like music like this?
Great music all the time.
Or like this?
The music you love.
Maybe this.
Great music that makes you want to turn up the volume loud.
Or life chat like this.
Especially where human life is concerned. Surely, sooner or later, people will realize that lives actually matter.
Then you're in the right place. Keep it locked to World Jam Global, where music is harmony.
Music 24 hours a day, 365 days a year.
Yeah, you're my World Jam. Hotter than them.
See live schedule.
It's for the people who are wondering why we're in the streets and we're outraged. It's basically a rundown of what's happened, and this is recent. And it's if you run, you die. Hashtag Walter Scott. If you stay and get arrested, you die. Hashtag Freddie Gray. Lay down while handcuffed, you die. Hashtag Eric Harris. Hashtag Oscar Grant. If you fight back, you die. Hashtag Trayvon Martin. If you mind your business, you die. Hashtag John Crawford. Put your hands up, you die. Hashtag Mike Brown. Proclaim your innocence, you die. Hashtag Eric Garner. Getting married, you die. Hashtag Sean Bell. Pansagging, you die. Hashtag Irvin Edwards. Beg for your life, you die. Hashtag Thaddeus McCarroll. Hashtag Cedric Barty. Just alive at 12 years old outside playing, you die. Hashtag Tamir Rice. Be outside, you die. Hashtag Rekia Boyd. Be at home chilling, you die. Hashtag Katherine Johnston. Run into your home, you die. Hashtag Ramarley Graham. Injured asking for help, you die. Hashtag Jonathan Farrell. Be in a stairwell, you die. Hashtag Akai Gurley. Smoke a cigarette, you die. Hashtag Sandra Bland.
World Jam Global Radio. This is clarity.
I already did my time. I paid for my...
I want to take this opportunity to introduce you to Issues Today, World Jam Global Radio, live going across the globe. My name is Kervin Julien. And you can follow us live on www.worldjamglobalradio.com.
I already did my time.
You can follow us live on Twitter, follow us live on YouTube, or you can follow us live on Facebook. We are live, going out from the UK, across the world. It's Issues Today on World Jam Global Radio.
Back in the day, I didn't really care about the system. It was all about survival. It was do or die. I had too many rivals. I was too young and foolish to stay in school. I learned my lessons in the streets. There was not a man I couldn't beat. I was good with my hands and very quick on my feet. I was swimming in women. I had girls all over the street. I was getting money. Life was so sweet. Now things have changed. The whole game has been rearranged. I'm a changed man.
So we really have a special show lined up for you today. It's our round table. We welcome back Jerry Summers, who's been away for a long time, and I'm going to leave it up to him to tell you where he's been and what he's been doing.
I paid for my crime.
We have Patrick Lane. We have Scott Russian. We have Yolanda McNair. And our very, very special guest today is Professor Seth Stoughton. And I think I pronounced it right that time. But we're going to be talking to all of these people very soon. But in the meantime, please do remember, Facebook has banned me until February 2020. So use this opportunity to share this stream live.
How my own supply. I'm not proud of what I had to do. That's why I'm telling my story to you and you. I had to repent. I must admit, I was doing all kind of stupid shit.
Share it with your friends, share it to your groups, because I am not allowed to share my stream from Facebook anymore. But if you're tuning in from YouTube, I'd like to say hi, how you doing? If you're tuning in on Twitter, I'd like to say hey. I don't know what else. Maybe there's a different language you say on Twitter, I don't know. What's your handle? If you are on World Jam Global Radio's website, welcome. Please use this opportunity to share these streams all over the world with all your friends and groups and sign into the chat rooms, and we can start to have a conversation. You'll be able to ask some questions as well as listen to some of the most significant people with something to contribute where issues relating to police brutality is concerned.
Already did my time, paid for my crime. Already did my time.
How we doing, PJ? I've been wondering about you. So Facebook has decided to ban me because we are getting so close to the truth.
My time. I paid for my crime.
It started when we streamed the Botham Jean roundtable show.
Ordinary citizen again. This is my message to
Botham Jean was killed by Amber Geiger, law enforcement officer who was found guilty and sentenced to 10 years in prison.
Very quick on my feet. I was swimming in.
And then when we was going to interview Annalisa Thomas,
money, life is so sweet,
who had won $13-point-something million from the state when they murdered her son,
and it ain't about
shot him with a single shot through his chest while he had his 4-year-old child in his arms on his doorstep.
This living hell. Already.
All hell broke loose.
I paid for my crime.
We were then hacked into by the FBI or law enforcement officers or whoever they were. They hacked into one of our shows, started to disrupt the show, and then before you know it, I had this anonymous ban which just doesn't allow me to share anything with anyone from anywhere. I can't even share from somebody else's page onto mine. It refuses to allow me. I've appealed, I get no response, there's just nobody there.
My own supply. I'm not proud of it.
But hey, Vanessa Whirling, in San Antonio, Texas, how you doing?
I must admit, I was doing all kind of stupid shit.
But this is Issues Today live on World Jam Global Radio. We have a host of guests lined up to speak to you today, alongside our special guest, Professor Seth Stoughton.
But I was nobody.
And I'll probably keep getting this pronunciation wrong as we go ahead. But you know, when he does introduce himself, please pay special attention to how he pronounces it. Although he says that he doesn't mind how it's pronounced at all.
Pay for my crime.
But it's courteous, right?
Time. Already did my time.
It's now been 6 years since we've been doing this Issues Today show live.
Things are going on right now. He could be facing life in prison.
Well.
And it's another huge roundtable show.
Trying to cope.
We are still struggling to get our host, my shotgun rider, my companion, TJ is struggling to get on the line. We can't seem to get her.
Yes, I am. Yes, I am.
So she's just going to be riding shotgun watching.
Trying to cope with this living hell. This living hell. This living hell. This living hell. Already did my time. I paid for my crime. Our Father who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven.
So TJ has just confirmed that she actually has a weather alert in her area, which is causing out her server not to allow her onto her streaming or her internet connection. So unfortunately, it looks like TJ is not going to be with us. Although I should imagine that she's going to try and listen as best as she can if she's got any access whatsoever.
Pay for my crime. All those drive-by killings, stop them.
Please use this opportunity to share this stream to as many groups and friends as you can. Again, as I said, I'm banned from Facebook until the 14th of February 2020.
I'm trying to get this felony up.
From sharing,
and get my life on track.
From resharing,
to live like an ordinary.
From posting in groups, from commenting in groups.
In the pen, statewide, worldwide.
I can like.
Those knives, stop.
Yeah, I'm allowed to like. Because Facebook can't do without the likes, can they? But hey. We're going to be live in just a few moments. Stand by. Okay. So, first and foremost, let me just say this. Are we really looking forward to a really tight and enthralling show, informative to say the very least? I'm going to be introducing my guests very shortly. TJ would normally step in and do this bit. It's all the introductions and stuff. But hey, she can't make it today due to a weather alert for her server in her area, which is not allowing her to get on. So our thoughts and our prayers are with TJ at this precise moment in time. Whatever she's doing, whatever she's going through, wherever she is, we're sending out her love and some good vibes down to her and her family down there. So, where shall we start? In a few moments' time, I'm going to start introducing our guests for you. But tomorrow I am in Doncaster, which is up north in the UK. And I'm actually, I'm going to be doing 2 gospel services for prisoners up in Doncaster tomorrow. So I need your thoughts and your prayers there. We're looking to reach out to the broken and the lost and hopefully give them some sense of worth and a purpose and a reason for them to really look for change in their lives. And on Thursday, I'm up in Rochdale, which again is north of England, in another prison for drug and alcohol recovery services. That's at Buckley Hall Prison. So I've got a busy schedule this week as far as prisons are concerned and trying to reach broken people, sharing my story as I go in the hope that we can bring about some sense and sensibility and the power of the Holy Ghost along the travels. So please pray for me in this week, and I'd appreciate that. On another note, I'm sad to say that our very, very first producer, Linda Sue, who helped set up this entire show format, she named it Issues Today, created the Issues Today Facebook page, and launched us on our way 6 years ago. Former director of Copwatch USA. She reached out to me 6 years ago in trying to find a UK representative for Copwatch and became my producer for almost 3 years, introducing me to some of the greatest people that I had the privilege to meet, especially in my early years of working with police brutality. And again, and I'll say umpteen times, when we started doing this show 6 years ago, it was never meant to be just focused on police brutality. It was meant to be subject matters of all sorts of stuff. That would relate to issues concerning our human rights, basic human rights, civil rights, and other menial issues around the world. Until I met Sue, Linda, and the first show that we ever did, we looked around the Tamir Rice case and some other things. I think we did the Cardiff 3 as well, was one of our very first cases. We did John Crawford, we did Sandra Bland, we did many cases back then. And she introduced me to all of those families and groups of people that launched me into this journey of police brutality. And unfortunately, just over a week or so ago, her sister got worried and hadn't heard from her for a week, so they called the police and they went down to visit at Linda Sue's home and forced entry and found her dead. She had passed away through a defect heart, which was a long-standing illness that she'd had, which is one of the reasons why she stood down as producer for Issues Today, was the fact that this hectic schedule that she had going in and out of hospital was having a real impact on her. So it was really sad when I received the news just over a week ago that Linda Sue had passed, but I don't think that we could do this show without honouring her for her part, her contribution to this work that we're doing here now and how far we've come. It all started with the conversation I had with Linda Sue 6 years ago. So our prayers are with her family, her sister, my second producer, Teresa Calderas, who was her very closest friend. Teresa took over from Linda Sue when Linda Sue became ill and was my producer for the next 2 years before she herself got ill. And but it was Teresa Calderas who contacted me to tell me that Linda Sue had passed away. So to her friends and her family and those people that knew her well, we say our thoughts and our prayers are with you, and she'll be sadly missed, and she'll definitely be missed from here. Okay, so that's Linda Sue. So also, before we go any further, I'd also like to introduce one of our roundtable panelists and a very dear friend. She's also been with me for a while now, and that's Yolanda McNair, and she has also lost her baby sister just in the last week or so, and I'll give her an opportunity to share that information with you. Hi, Yolanda. Hi, Yolanda.
How you doing?
Yeah, how are we doing, Yolanda?
Yeah, I'm here.
Yeah, it was with great sadness that we heard this news this week, and our thoughts and our prayers are with you and your family. But tell us just a little bit, please.
Okay, thank you. My baby sister, she's 7 years younger than me. I've always had fun hanging out with her while we grew up. During our early 20s, right before I got married, I introduced her to my first husband. She was still a little kid, so we took her to a park and played with her all day. She said that was one of the best memories she ever had. And then after I got married and had my kids, we kind of lost touch for a little bit. And she came back into our lives shortly before I lost my daughter, Daisha. And she had the opportunity to meet her nieces and her nephews, and she was just, super happy, and we got to meet her son. But she's always been a person who had a smile on her face, a good word coming out of her mouth, and it just, enjoyed life. I had made plans to meet with her when I got back in town. I was going to visit our other sister in Georgia, just to find out that 6 days after I spoke with her, she had passed away in her sleep at the young age of 44.
That must have really shook the family considerably, I'd imagine.
Yes, it did. Yes, it did. Like I said, she's the baby. I'm the second oldest, and we just, nobody was ready for that. Nobody had that idea in their head. But it's difficult because we never had opportunity to say goodbye, or and we're still waiting on the coroners to tell us what happened. Whether it was her heart or something else, but we're just stuck in limbo.
Oh, well, Yolanda, just know, as a family here on Issues Today, and especially from your roundtable team, we are with you. We are here to support you. We will lift you up and the family up in prayer. And we are so sad at your loss. And I just wanted to give you a few minutes just to honor that and give you an opportunity to share that information.
Thank you.
Go on.
Her name is Chanel Yarbrough, for those who know me and my family. So, if you wanted to go to her Facebook page, you can leave a message there for her.
Okay. Well, listen, thank you very much for that. But now we're going to move on very quickly because we've got about an hour and a half left. And we have a very special guest, which we're going to be introduced shortly. But the other thing that I wanted to say before we went any further was it's a great honor to welcome back the father of the house, the father of the roundtable team. He's not been here for a while. We've missed him so much. And I don't think anybody knows just how much joy I have in knowing that we have the return of the Right Honourable, because we've got to give him a title, right? The Right Honourable, the very irrepressible former Chief of Police of Idaho, Mr. Jerry Summers. How are you doing, sir?
I'm doing fine, and you are so kind.
Jerry, we love you, Jerry. We absolutely love you. We adore you. We missed you. And we're just so glad to have you back. But what's been going on for you in this time that you've been away?
Just gotten very busy. I started a company with my son who then left the company, and it took me, probably 4 months to get it back on track and inundated. I got that taken care of, and we're back on an even keel. So we should be fine now, and I should be much more of a regular on this show once again. And I love being back.
Wow. Well, it's going to be great to hear your contributions and your input, especially on this. Now, before I introduce everybody else, which we will do, let's just make it clear. Qualified Immunity Unpacked is the title of this show, and most of you that have been following the show will be fully aware that we've been looking at this issue on qualified immunity for some time. We've been trying to unravel it, discuss it, open it up, and try and give our audience an understanding of what this qualified immunity is, and how it affects your cases in particular. But today we have our very special guest, who's a professor of law, and this is his area of expertise, and I'll be introducing him very shortly indeed. But before we do that, let's just introduce the rest of our panel. Firstly, let's start with Mr. Patrick Lane, again, who is another hard-working member of this roundtable team and a great contributor, and it's great to have you on board. How are we doing, Patrick?
I'm doing great, and I'm so excited to have Jerry back. Jerry, you have been sorely missed, and I'm especially excited to hear the professor talk today. So I'm really looking forward to this show and really, really happy to be here. 30
seconds, 1 minute, Patrick, on why you are involved in police brutality.
On May 31st of 2014, my nephew, Taylor Rock, was set up by two officers, one which he had a child with. The woman he had the child with, who was a corrections officer, wanted the child that she shared with Taylor back and couldn't legally compel him to give the child back. And so she had a deputy from the agency that she worked with stop him. And Taylor was killed. No criminal offense, no trouble, nothing from Taylor, was killed on the side of the road. And in 5 years, we still haven't received full police reports. We haven't been able to recover any of the evidence that was taken at the scene. Actually, nothing has been released by the county where he was killed. So that's why I'm here. And not just for Taylor, because and all the people that have lost someone, we're not here for our loved ones because we can't get them back, but we are here for those that come after, and that's why I'm here.
Amen. Just before we go any further, I just want to say this, right? So you guys are aware of the interference that we've had from local or for law enforcement and the FBI, etc., over the last few weeks. The interference. I was talking in work last week, and I was actually laughed out of the room by most of my colleagues in work, who could not believe that the FBI or law enforcement would even be interested in what we did here and what was going on. And they actually laughed me out of the room, a lot of them did, and totally disrespected the fact that we would be interfered with. But we witnessed what took place that day. We knew, we heard the voice. Some of you saw the face of the law enforcement officer that hacked into our call. We know that it's real, and I'm not really worried about those that find it funny or amusing. This is some real serious stuff that we do here week in and week out. So it's really great that you guys, in your pain and what you're going through, can come and share your stories on here, that other people might benefit from what you've got to contribute and share. So I personally honor you guys, and we're fully aware of the impact that we're making as far as police brutality is concerned, and the corrupt law enforcement officers of the United States of America, and some of the negative practices that are carried out there that really bring about an injustice and a disservice to that unit. So I'll just leave that there. I don't want to go on a spread. So let's go to Scott Russian. How are we doing, Scott? Introduce yourself.
Can you hear me okay?
We can hear you clearly.
I'm doing fine. Thank you. Thank you to Professor Seth and the group. Yeah, my short story, and Kervin and I have been talking for a while. I was introduced to Kervin by David Phillips. David Phillips is a black man whose son Desmond Phillips was killed by the Chico Police Department in March of 2017. And my son was killed by the officers of the Chico Police Department and others on July 23rd of 2017. And several of the officers that killed Desmond Phillips, 24-year-old young black man, killed my son, a 34-year-old young white man. And so David Phillips and I, of course, have bonded, and we're both fighting legally to get justice for our sons. And David introduced me to Kervin, and Kervin and the group and I have become pretty close over the last 30 months or so. So that's why I'm here.
Amen. Thank you very much for that. And we're not just close; we're like family, right?
I hope so. I believe so. Yes.
That's exactly where we are. Yolanda, how are we doing? Founder of Post Protect Our Stolen Treasure. Please introduce yourself and give the audience an understanding of why you're here.
Hi, my daughter, Daisha Miller. Hold on, let me turn this fan off.
She's got to turn the fan off.
Okay, my daughter, Daisha Miller, was killed by a Detroit police officer who was off duty at his home having a party the day before her 25th birthday. The police officer sat at a desk for 2.5 months and was cleared of all wrongdoing by prosecutor Kim Worthless. That's what we call her. Her name is Kim Worthy, Wayne County prosecutor for the state of Michigan, without the investigation even being completed. So in my way to fight back and honor my daughter, myself and some other family members who lost loved ones to police murder, we created POST, which stands for Protect Our Stolen Treasures. And we are the only family-based organization that's in multiple states. We have chapters in Greenville, South Carolina, Columbus, Ohio, Portland, Oregon, Wichita, Kansas, and Lawton, Oklahoma. And we plan to expand some more.
Great work. And you guys continue to do good work. And we honor that, and we thank you for, being part of Issues Today, and more importantly, Yolanda, being the mother of the roundtable team alongside Jerry Summers, the father, the absent father, but he's returned. But yeah, it's been a real honor to take this journey with you guys as we do here on Issues Today, week in and week out, for as long as we've been doing it. The Issues Today next year will celebrate its 7th year of undisrupted, continuous streaming, live streaming across the world, as we do, as the paramount first base police brutality support group with a platform for families to tell their stories, and the only one that we know of its kind in the world. So we look forward to doing many more years. Well, we don't actually, because we'd like to stop doing this one day, because if we stopped doing it, it would actually mean that they stopped killing innocent people. So it's not something that we would love to continue to do. It's something that we'd love to stop doing. But until such time, we will continue to do it and give families that platform that they need in order for them to tell their story and share their story. Finally, our final guest, and I'm going to leave him to do all of his introductions. This man is a professor of law, and his area of expertise is that very, very fragile subject, qualified immunity, which we're going to unpack today. It's Professor Seth Stoughton. Did I pronounce it right, Seth?
You did. Thank you, Kervin. Thank you for having me.
The honor is out. The honor is all ours, Seth.
I am a law professor in South Carolina, at the University of South Carolina. And for the last 8 years now, I've studied as an academic policing and the regulation of policing. What I mean by the regulation of policing is the rules, both the legal rules and also the less legal rules, the non-legal rules like agency policies, procedures, doctrines, and even informal rules like police culture that shape officer conduct. The goal is to better understand how we can get officers to do what we as a society want them to do, and also how we can encourage them to not do things that we as a society do not want them to do. I've focused, my last couple of years have been focusing on police use of force. I have a book coming out with a couple of co-authors next year called Evaluating Police Uses of Force. And qualified immunity plays a pretty significant role in the regulation of policing and in particularly in this use of force context. I'm also a former police officer. I served for 5 years as an officer with the Tallahassee Police Department in Florida, and for almost 3 years as a state investigator doing criminal and administrative investigations. All of that was prior going to law school. So I hate long introductions, and I'm always very uncomfortable introducing myself, so I look forward to getting into the meat of this very important and very difficult conversation.
Wow, well, I mean, what a CV. Maybe we need to invite you to be a regular member of our roundtable too. Yeah, so that's great, and it's really fantastic to meet you, Seth. And you was introduced to us through Scott. Scott really made a real attempt to bring this thing together, and between him and the work that was done by our very own TJ, Teresa Gallagher, who is the producer of this show, we was able to bring this about, and we really welcome you. And we're going to honor you here today and give you an opportunity to unpack qualified immunity for us. Now, for the simple layman, give us a brief explanation as to what qualified immunity is. What is it?
Sure. And even before we start talking about qualified immunity, I need to give a little bit of background so that you can understand where it fits in the fairly complicated legal landscape. When an officer engages in misconduct or in something that is alleged to be misconduct, there are at least 3 different mechanisms that misconduct or alleged misconduct might be used to address that incident. One of them is administrative discipline. An officer might be investigated and disciplined by the agency that they work for. This is purely administrative. This is no different than any employer disciplining any employee. It's a little bit different because we're talking about a government employer and some special rules apply. But effectively, it's no different than any employer disciplining any employee for doing something wrong. There's also criminal sanction. If an officer's actions amount to a crime or the prosecutor thinks that there's probable cause that the officer committed a crime and that they can potentially establish the commission of a crime beyond a reasonable doubt, the officer might be criminally prosecuted. And then there's a third area, and that's where we're going to focus, and that's civil liability. An officer who harmed someone or harmed someone's legal interests can be sued civilly for a couple of different possible things, one of which is money damages. They can be sued for money to attempt to compensate the victim for the injury. They can be sued for declaratory relief so that the court will declare that the action was unconstitutional. They can be sued for an injunction that orders the officer or the agency to not engage in particular conduct in the future. Within the civil lawsuit sphere, an officer can be sued under state law or can be sued under federal law. An officer can be sued under state law for what are called state torts. Battery, for example, is a crime in all of the states, but it's also a tort. So if someone hits you, and I'm not talking about in the police context now, let's just say you're out and about and someone punches you, they just committed a crime, but you can also sue them civilly to cover your medical expenses and the like. While officers can be sued under state law, they can also be sued under federal law. There's a federal statute, 42 U.S.C. Section 1983, that Congress passed way back in the 1870s that allow individuals to sue government agents, including police officers, for constitutional violations. You can't sue an officer for violating Section 1983, as it's called, because Section 1983 doesn't provide any rights. It doesn't lay out any rules for the police. It just allows someone to sue the police for a constitutional violation. The use of force is regulated constitutionally by the Fourth Amendment. When officers use force, it is often considered a seizure, and the Fourth Amendment protects against unreasonable searches and seizures. So an excessive force claim is a Fourth Amendment claim. Someone can sue an officer under 1983 alleging that the officer violated the victim's Fourth Amendment rights to be free from unreasonable seizures. And at that point, that's where qualified immunity comes in. So among the things that we might talk about today is what exactly the Fourth Amendment permits officers to do and what it does not permit officers to do, and how qualified immunity, where I think we'll spend most of our time, how qualified immunity affects and complicates that analysis. The Fourth Amendment allows officers, and I'm going to speak at a relatively high level of generality, at least at the beginning. I'm happy to get into more detail as we go. The Fourth Amendment allows officers to use force that is objectively reasonable. It prohibits officers from using force that is not objectively reasonable. So in any given case, the Fourth Amendment question, that is the question of whether there was a constitutional violation, is, was the officer's action objectively reasonable or not? Qualified immunity adds another layer to that. It adds a wrinkle to that. Qualified immunity is a doctrine that protects officers from lawsuits unless their actions were unreasonable, unconstitutional, and it would have been clear to a reasonable officer at the time that the action was unlawful. So the way it works in practical terms is this: an officer uses force, someone files a lawsuit alleging that the officer's use of force violated the Fourth Amendment. The officer then files for what's called summary judgment, asking the judge to decide that case in their favor before a trial and before, after the production of some evidence, but before the production of some evidence as well, on the grounds of qualified immunity. If the judge says, yes, I think there is qualified immunity here, that is the end of the lawsuit. It goes no further. If the judge says, well, I don't think that I can award a qualified immunity here, I don't think that it applies here, only then can the plaintiff continue bringing their case and proceed to trial. So in practical terms, qualified immunity can be a very substantial barrier to trial. And of course, if you don't get to trial, then you don't get to a jury, you don't get to a civil judgment, and that's the end of the lawsuit. If qualified immunity applies, the lawsuit is over.
Wow. Let me just bring in Scott very quickly. Scott, based on what Professor Seth has just explained, do we think, because it sounds like it's almost like a closed shop, it's like a pre-court hearing, which majority of people don't get to partake in or don't even know exists or takes place. And then they have this little conversation, and it's like a little, buddy, friend thing, and they sit down in a room, and the judge says, well, you know what, qualified immunity stands here, and that's the end of it, right? Do you think, based on the types of shows and families that we have interviewed, alongside your own personal case, right, and some of the things that you've experienced since you've been introduced to police brutality and victims of police brutality, do you think that this qualified immunity, based on what we've just heard, has then been misused?
The short answer is yes. The pattern, which I think Professor Seth will agree with me, is that the coziness, which I stole that phrase from somebody, between the investigators, like the district attorney in California, and probably similar across the United States. Some investigator, they're too close to the police officers that commit the crimes. So when it comes to defining what is reasonable or what is unreasonable, did an officer act reasonably? Did an officer not act unreasonably? The semantics of the legal world, that's where Professor Seth is a pro and I'm an amateur. But the bottom line is the district attorney in too many cases, and I've talked to personally, Seth, 7 families that have had loved ones killed by police officers. I, over the last year or so, talked to 7 separate families. The patterns are similar in each of these cases, where the investigative agency, let's say the district attorney, has done a very, I would say, cursory investigation and basically stood behind the qualified immunity statutes to, in effect, block the ability of the family, and this is in 7 cases, to exercise their legal rights, a 4th Amendment claim, a 14th Amendment claim, to get to a civil trial. And it's such a big hurdle, financially, emotionally, for these families. And I'm talking 7 families. I'm not talking hypothetically. These people are all struggling to find an attorney who will take a trial, a trial attorney who will fight for their civil rights. And once they find that attorney has to be clever enough to overcome these obstacles. And you add it all up, plus qualified immunity is the trump card. And I don't mean that as a pun. It is a trump card that it appears that the law enforcement can just pull out and say, maybe our guys did use unreasonable force, shouldn't have killed your family member, but you know what? They have qualified immunity. So I'm not going to press charges. And yes, Kervin and Seth, I can tell you I'm one of 7 families within the last few months that have had loved ones killed and they will agree that the pattern is the same in every case. The coziness, the unwillingness to file charges, the vilifying of the deceased, the smearing of the family, and then the obstacle created by qualified immunity and the ability to get to a civil trial. And to me, the upshot is these 7 families, including mine, do not trust the system. They do not trust the investigation. They seem illusory. They seem quick. They seem predetermined and unfair to the civil rights which theoretically are guaranteed us under the 4th and 14th Amendment. I'm not an attorney, so I don't want to go there, but you understand my point of view as just a citizen, a family who've lost a loved one. We want our day in court, Seth. We want our day in court, win or lose. And we just can't get there. So I'll leave it at that.
Let me bring in Jerry Summers very quickly. Jerry, qualified immunity or no qualified immunity, the fact that the police have the standard, I was in fear of my life rhetoric to use in order to defend themselves in most cases. Why is there a need for qualified immunity as a trump card to trump the, in my opinion, because that's what it feels like. It's like, well, if we can't get past, if we can't get through with the I was in fear of my life, and somebody can disprove that there was actually no reason for you to be in fear of your life, then, hey, don't worry, I got the ace up the sleeve. I got qualified immunity. Why is there a need for qualified immunity if they've already got the permission, so to speak? Because let's just, before we go to that, and again, sometimes I do this and I mix up the whole load of stuff, because understanding the law of what a police officer is allowed and not allowed to do, just correct me if I'm wrong, an officer is not allowed to offload his weapon unless there is clear and imminent danger. That was always my understanding. Now, if that being the case, and clear and imminent danger has been disproved, why then give the trump card of qualified immunity as an additional protective measure? Because that's what it looks like to the layman, Joe Bloggs on the street.
Let me see if I can answer that quickly. Qualified immunity, there is no doubt in my mind it's being abused, and the courts are allowing it to happen. The prosecutors and attorneys are allowing it to happen, and it's being abused. And a big part of that is the culture in which you find law enforcement where a reasonable officer standard, one officer is not going to find that the other officer acted unreasonably because the culture doesn't allow that. That's the whole wall of silence and the thin blue line. But let me give you an example where qualified immunity worked in my case. Brand new officer, first arrest out of the academy. I arrested a woman for violation of a protection order. That order had been quashed by a county in Idaho, 100 miles away, but they had never put it within the system. I arrested her. She went to jail. She spent a night in jail, turned around and sued me for false arrest, and sued me personally as well as the agency for false arrest. Now, I had checked through dispatch 3 separate times to make sure that order was still in effect before I made the arrest, and was told that it was. So in that instance, I could not be sued because I acted reasonably and with good faith. And that's where qualified immunity protected my personal assets from seizure or from attack by an individual. I arrested her incorrectly, but I had no way of knowing that, and I did everything I could to make sure it was a valid arrest. Therefore, qualified immunity worked for me in that instance. And that's what I believe it was designed to work for in their times. Qualified immunity has been said by, I believe it was the Supreme Court, and Seth can tell me, that qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. Those are some broad statutes. Plainly incompetent, you're not going to get another officer unless it's very egregious to say that the officer was plainly incompetent. And then to prove that somebody knowingly violated the law is not an easy standard either. So when you look at those statutes and the meaning of qualified immunity, there's a broad shield that any government agency or government employee can fall behind, especially the police. And that ties in also to prosecutorial misconduct where they have absolute immunity. And I think both of those need to be looked at and revisited by our courts. But the plain fact is our courts are not holding officers and or prosecutors accountable for wrongdoing.
How does that pan out for you, Seth?
Yeah, thank you for that. There are a couple of things there that I want to clarify just a little bit. One, so qualified immunity applies to the civil context and it applies to federal claims. Technically, and I realize that there is a slight difference here between technically and practically, but I'll get to that in a second. Technically, when a prosecutor is reviewing a case to figure out whether an officer should be charged criminally, qualified immunity plays no role in that particular analysis. Qualified immunity only comes up in the context of civil lawsuits against the officer. Now, I don't want to make too much of that distinction because Scott is absolutely right. The relationship between an officer and their agency and whoever is conducting an investigation into the shooting, and the relationship between the officer and the agency and the prosecutor or the district attorney can have implications for that civil claim. Specifically, the evidence that is available to the plaintiff's attorneys who might be looking at filing the lawsuit result from that investigation, and the evidence that's available to the defense attorneys who are defending that civil lawsuit come primarily from the investigation. So if that investigation was conducted in a way that is not as robust as it should be, or that was worse, designed to protect the officer rather than really identify all of the relevant facts, it can certainly have a significant impact on civil claims. I also agree that there is some troubling coziness, and that is a good choice of words, Scott, wherever you got that, between officers and district attorneys. Formally, they are separate entities. They are both members of the state or local executive branch, but that's it. They don't work for each other. Practically, the prosecutor relies on police officers and police agencies to conduct the investigations and make the arrests that the prosecutors then go ahead and prosecute. So there is some professional interdependence there. And Jerry was entirely right. The Supreme Court has said that qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. That's from a case called Ashcroft v. Al-Kid in 2011. Qualified immunity provides a pretty high bar. It makes it very difficult to sue civilly officers for constitutional violations. We should start, as Jerry did, by noting that there are some legitimate values to, or some legitimate concerns about exposing officers to too much liability, about leaving officers too exposed. The nature of policing in many cases is inherently uncertain. Officers are going to make mistakes for a couple of different reasons. Sometimes the situation is such that information that appears to present itself really isn't correct, as in Jerry's case there, where there was a warrant that was no longer active, but the information he had is that it was in fact active. Sometimes there just simply isn't sufficient information to allow for the best possible or most accurate possible decision. Officers operate in areas of uncertainty all the time. That is one of the realities of policing. Qualified immunity was developed in part to help protect officers, and really not just officers. Qualified immunity was not developed in the context of policing. It was developed in the context of high-level aides to the president, actually. If government officials are so concerned about liability, they may not be able to do their jobs. And that gave rise to qualified immunity as a way to help reduce their concerns, their fears of liability, so that they could do the job that we, the public, need them to be able to do. That said, qualified immunity has gone too far. It makes sense in the context of high-level presidential aides, the case where the court really started to articulate that the qualified immunity doctrine, but it makes significantly less sense when we're talking about the street corner politicians that are police, the folks who are the low-level rank and file officers who are doing the vast majority, the backbone of modern policing. It also makes a little bit less sense in the specific context of the Fourth Amendment. And to understand that, again, we have to remember that the Fourth Amendment allows officers to take actions that are reasonable. When officers want to make an arrest, for example, they have to have probable cause. That is, they have to have enough evidence to, as the courts put it, warrant a man of reasonable caution in the belief that someone has committed a crime. That doesn't have to be perfectly accurate. The officers might be wrong about that. The officers might think that someone committed a crime when in fact they didn't commit a crime. But as long as the officers reasonably thought that that someone committed a crime, they have probable cause to believe that that person committed a crime. So let me clarify that just a little bit. If officers want to arrest someone and they think that that person, they have evidence to suggest that that person committed a crime, and they make that arrest, and then later it turns out that that person did not commit a crime, the officers thought they did, but they were wrong, that does not violate the Constitution. You don't even get to the question of qualified immunity. There's simply no constitutional violation there because officers can be wrong. Probable cause, the standard for making an arrest, does not require complete accuracy. It just requires, well, probable cause. Qualified immunity adds an additional layer of protection by saying that if there was a constitutional violation, that is, if officers did not have probable cause, then they still can't be sued because of qualified immunity unless every reasonable officer would have realized in that situation that there was no probable cause. So bear with the semantics here for just a second because this is a little bit confusing. If officers did not have probable cause, but a reasonable officer could have thought that they had probable cause, then qualified immunity applies and the officer can't be sued for what is an admittedly unlawful arrest. And that is where, for me, qualified immunity starts to break down a little bit. The Fourth Amendment allows ample room for error. It does not expose officers to liability for every possible error. It exposes officers to liability for unreasonable errors. As long as an officer is acting reasonably, and as long as their errors are reasonable, then they are not violating the Fourth Amendment.
Okay, one second. What do we define as reasonable? Because this word keeps coming out. And let me tell you why this word keeps coming out, right? In the clearly established law requirements of qualified immunity, hear this because this really blew my mind. We discussed this on a couple of occasions. It says this: qualified immunity does not protect officials who violate clearly established statutory or constitutional rights of which reasonable person would have known. This is an objective standard, meaning that the standard does not depend on the subjective state of mind of the official, but rather whether a reasonable person, this word reasonable comes in again, would determine that the relevant conduct violated clearly established law. Now, here's the thing for me, Seth, and quite rightly so, you guys have pointed out, right? This word reasonable, right? Anybody who has been employed in a job of work is expected to undergo a certain amount of training to qualify him or her to be able to be efficient in that role that they've just been employed in. You would imagine somebody who takes on the role of protect and serve, right, your nation, and you're going to be a law enforcement officer, where the integral role that you're expected to play is of the highest standard. You'd expect that person to be reasonable. You'd expect their understanding to be reasonable. You'd expect their thought process to be reasonable. You'd expect their training to be reasonable. You'd expect their information conception to be reasonable. You'd expect that person to be reasonable. So I don't quite get how they use this word, and you've used it several times, and I understand why you're using it, and this is not an attack on you, because I just need you to break this down for me, right? Is how on earth they determine what is there a psychological evaluation that goes through to determine whether or not an individual is in the right state of mind at the time that he actually carried out the act, in order for him to be determined to be reasonable or not reasonable, or understand reasonably or don't understand reasonably? What qualifies the person to be reasonable or unreasonable?
Yeah, that's a great question, and it's one that I pose to my students all the time. What exactly do we mean by reasonable, and what do we include and what do we exclude when it comes to this concept of reasonableness? I wish I had a better answer for you. In a recent article, a co-author and I, Brandon Garrett and I, argued that one of the fundamental problems in the Fourth Amendment's regulation of police use of force is the court's failure to define reasonable. And specifically, the court's failure to look at police best practices and evidence-based practices in the determination of what's considered reasonable. In 1985, the court decided a case called Tennessee v. Garner. This is the deadly force case in the United States, or at least it was until more recently with a case called Scott v. Harris. In Tennessee v. Garner, the court an officer in that case, an officer in Tennessee, responded to a burglary, and a young man, ended up being 15 years old, exited the house that was being burglarized and fled from the officer. And the officer, as the suspect was running towards a fence and starting to climb a fence, the officer realized that the young man was unarmed, but also thought that if the young man climbed the fence, then he was going to escape. So the officer did what the law at the time seemed to allow him to do. He fired one shot, striking the young man in the back of the head and killing him. At the time, the law that applied there was called the fleeing felon rule. It allowed officers to use deadly force to prevent the escape of a fleeing felon. In this case, burglary was a felony. This person was a fleeing felon, so the officer used deadly force. The Supreme Court said that the Fourth Amendment did not allow the fleeing felon rule, that as a matter of constitutional law, the Fourth Amendment was more restrictive than the fleeing felon rule was. And to come to that decision, one of the things that the court did is look at what police agencies themselves were actually doing. It looked at the FBI, it looked at the Boston Police Department, it looked at dozens of police agencies and said most of the police agencies that we're looking at have already told officers that the fleeing felon rule no longer applies. It holds officers to a higher and more restrictive standard. And there was research submitted by a professor and police lieutenant named James Fife, a criminologist, who said that the fleeing felon rule wasn't actually very helpful in terms of apprehending people either. It didn't discourage people from running from the police. So there was really no justification for it. In other words, as the court was figuring out what the Fourth Amendment allowed or did not allow, it looked to the police industry itself to figure out what agencies were doing. After Tennessee v. Garner, the Supreme Court basically stopped doing that. Now it develops its concept of reasonableness by, I mean, I wish I could say this a little better, but really just by making it up, by gut sense, by taking evidence wherever it happens to look, rather than actually looking at developed best practices, generally accepted police principles, or evidence-based practices. So the answer to your question, what do we mean by reasonable? I'm not being pithy, and I'm being a little bit sardonic when I say, I guess it means whatever the Supreme Court says it means. But I'm actually going to get even more depressing for just a second, and that's by shifting from the Fourth Amendment standard of reasonableness to the qualified immunity's clearly established prong, which you brought up. Again, qualified immunity applies unless the constitutional violation, unless the action in question was clearly established as a constitutional violation, unless it was clearly illegal at the time of the violation. And the Supreme Court has said that that generally requires some prior case with similar, although not identical, facts to have been decided that clearly established that what the officer did was wrong. So when an officer does something to figure out whether it's clearly established, we start by looking at earlier cases and say, well, is there anything similar here? One way of looking at that clearly established prong is you could imagine it occurring or it being applied at a fairly high level of generality. An officer used force. If that's excessive force, well, certainly it is clearly established that officers can't use excessive force. That's too high a level of generality, the court said. We can't just look at the right itself. We have to look at the specific facts and say, under these specific facts, is it clearly established that the officer's actions were unconstitutional? And often, although not always, often that requirement to have a similar case on the books establishing actions, similar actions as unconstitutional, will prevent civil liability. It will result in the application of qualified immunity.
Wow. This unpacking of qualified immunity is really blowing my mind. I cannot thank you enough for agreeing to come on the show, Seth, and doing this for us. We wasn't meant to have our next speaker on the show, but she's also a member of our roundtable team. She's the baby sister. She's my little sister. We family. She's the sister of murdered Andre Gladden. You may have heard of the case of Andre Gladden. He was a man that was registered blind when he was murdered by police. And Dee Martin, his sister, continues to fight for justice. But she was asking a couple of questions on the Facebook stream, and I asked her if she wanted to come in and ask that question directly. And she said yes, so here she is, Dee. And if Dee wants to give a quick brief introduction into who she is before she asks her question, we can also accommodate that. How are we doing, Dee?
Good morning. I'm great. Thank you for having me on. I was just listening, but I did have a couple questions that came up. I'm in a hollow space, so hopefully you all don't hear the echo. Am I coming through clear?
You're coming through okay.
Okay. And as Kervin said, my name is Dee Martin. I'm a sister of Andre Gladden. He was registered blind, murdered in Portland, Oregon, in January 1st of 2019. So it's still very recent. I'm not sure if this question is so much of an off topic, but unpacking a qualified immunity, the more clearer it gets, the more unclear it is, if that makes sense. It's still pretty unbelievable for me to even have that scapegoat as an avenue for law enforcement. Speaks volumes, in my opinion. But in regards to my question, for Andre Gladden, the person who testified against him on the behalf of law enforcement was a person who was not there at that point of time and also legally deemed 5150. And the courts allowed her to testify on the behalf of the officer, changing the narrative from multiple different stories. And I just want to know the evaluation of the witnesses before they get on the stand or grand jury to testify on the whether the officer's behalf or the witness or the victim's behalf. Because as far as I know, and this is a family member that I'm speaking in regards to, so you have the victim, that is my brother, and you have the witness as also a family member. But the mental competence of this individual, she was not there at that time, and she's legally deemed 5150. And what type of procedure do they have to undergo to be able to testify on either the behalf of the officer or the behalf of the victim? So I was kind of baffled as to how that happened, as to where she can even be named a witness, being miles away from the altercation when it transpired, let alone the 13 other officers that were deemed witnesses as well, even 45 seconds after everything had transpired. So I wanted to see if you could possibly shed some light on the process of how that goes or how it's allowed in the courts, if it's a normal process or how that goes.
Yeah, thank you for that question, Dee. It's a very good question. So there are two types of witnesses. There are what are called lay witnesses or fact witnesses, and then there are expert witnesses. A lay witness or a fact witness is someone who is testifying about something that they observed or did, something that they saw, something that they heard, something that they personally perceived, and potentially how they reacted. So when an officer is testifying about what they did, or when a plaintiff who was injured by police is testifying about what they did, they are fact witnesses. And fact witnesses are really only allowed to testify about the facts that they perceived. They can't testify on behalf of someone else. They're not really allowed to speculate. They are allowed to testify as to their own perceptions and conclusions. There's another type of witness, though, and this is an expert witness. And for purposes of full disclosure, I will say that I have testified and continue to testify as an expert witness in police cases, police litigation. Expert witnesses are not testifying about their perceptions. They are instead testifying as to their expert conclusions. So they get a body of information. They might get all of the police reports or videos or statements or deposition testimony that have already been developed. They get the record that's been developed in litigation. They review the record, and then they essentially say, looking at this information, here are my opinions as an expert in that area. So what does it take to become an expert, or what does it take to provide expert testimony? There are really two different types of expert testimony, one of which is scientific expertise, and the other of which is non-scientific expertise. Scientific expertise is the easier to deal with. We look at, under a case called Daubert, D-A-U-B-E-R-T, Daubert v. Merrill Dow Pharmaceuticals. The Supreme Court said that we analyze whether someone is an expert by looking at whether they are applying a standard theory or technique, whether that theory or technique has been peer-reviewed, whether the technique that they're applying has identifiable error rates, whether there are standards that control its application, whether it's been widely accepted within the scientific community. So, for example, DNA evidence. If someone wants to testify about DNA evidence, we have a lot of peer-reviewed research on the techniques that you need to analyze DNA. We know what the error rates are. There are standards that control DNA testing, and we know that those standards and the concept of DNA testing has been widely accepted. So if someone is applying those standards, they're allowed to testify as an expert. In the use of force context, it's a little bit different, though, because the use of force is not really science. It's more of an art, if that makes any sense. It is a little bit of a squishier standard, and essentially we apply similar rules to the scientific evidence standard, but we don't have the same techniques or concepts, so we tend to look at things like whether there is an established methodology, whether the individual is applying the analysis in a consistent way or in line with what experts in the field, even though it's not a scientific field, what experts in the field do. So, for example, when I am preparing a report or testifying as an expert in a use of force case, I say, here are the constitutional doctrines that regulate the use of force. Here are the administrative doctrines that regulate the use of force. Here is how I am going to look at the facts. Here is my understanding of the facts, and here is how I understand those doctrines and rules to apply to the facts in light of what I know about police best practices and generally accepted principles. Jerry, I think you've done some work in this area too, right? Do you want to add to that? See what I'm leaving out?
I think you've got it right on. Yes, I have done some work in that area, and I think you're right, spot on. So I don't really have anything to add.
There's going to be 1,000 more questions that we're going to sit down at the end of this show and think we didn't get to ask. But TJ, our beloved producer, without trying to shift or move from where we are, wants to get in this question, which is, if an ATF agent is on a ride-along in an unfamiliar area, states, is that moonlighting, or do off-duty cops carry the same as if they're on duty? Does that make sense?
It does, yes. Excellent question. So, yeah. Okay, so we have to go back to Section 1983 for just a second
sorry,
here,
Steph.
which is...
I suppose I would imagine that would really mean that if a ride-along was in a vehicle with another officer going into another state, for example, and an incident took place, would he have the rights, the same rights, to offload his firearms and participate in this activity as if he were in his own state? Is he still governed? Is he still licensed? Is he still covered? I'm quite sure that's what we're trying to talk about here, isn't it?
Okay, I misunderstood the question. I was literally looking at it from the other angle about whether you could sue the person, sue the agent in that case. So that's really a question about jurisdiction and where and how officers can act. Federal officers generally have jurisdiction to act as officers anywhere in the United States. That includes while they are off duty, unless there are some specific prohibitions in place. But essentially, an officer is vested with authority under federal law for federal agents, or under state law for state and local police officers. The fact that they are on duty or off duty is really not legally relevant to the question of whether they can take police action. They are empowered to to take police action. Now, one slightly complicating factor here, and I realize I'm adding a lot of complicating factors to this conversation. I apologize for that. It just really is a complex area. Officers, an officer may use lethal force in the context of their job, and it is also the case in the United States that someone may use lethal force for purposes of self-defense. There are, well, hang on a second. Let me try and figure out the best way to address this. Sometimes an officer will be, okay, sorry, I have to back up another half step.
That's okay.
So, in the United States, every state has some rule, either by statute or common law, a judge made a judicial opinion. Everyone has the right to use force in self-defense, including in many cases, or including in some contexts, the right to use deadly force in self-defense. Officers also have some additional legal authority, or some different legal authority, to use lethal force in the context of their jobs, like as a police officer. And in some cases, what we've seen is arguments over whether officers have the legal authority to use force as officers, and if they don't, whether officers have the legal authority to use force as a civilian, as any community member. So there were a couple of prosecutions of police officers in Florida, where officers shot and killed someone, two different people, and the prosecutors pressed charges, and the officers argued that there were statutes that allowed them to use force as police officers, and the prosecutors argued successfully, no, you cannot use these statutes as a police officer. The police officer use of force statutes do not allow you to do what you did. So then the police officers said, well, even if we don't get to use deadly force as officers, we're allowed to use deadly force as civilians under Florida's Stand Your Ground Act. Originally, the trial and appellate court, well, it doesn't really matter what they did. One allowed the officer to raise that claim, the other did not. The Florida Supreme Court, the state Supreme Court, said that as a matter of Florida law, officers could rely on both the police-specific authorization to use deadly force and also the general Stand Your Ground Act self-defense authorization to use deadly force. So in the specific question that you're asking about an ATF agent, one, it is probably the case that the officer retains the legal authority to act as an officer even while off duty. And two, even if they don't, they may be able to argue that their actions were authorized as a matter of state law, state self-defense law. What you're seeing here in part is another example of these multiple layers of protections that can exist to empower officers to use deadly force. Just like the Fourth Amendment and then the just like the Fourth Amendment provides one layer, some tolerance for mistakes, and then qualified immunity adds another layer of protection. At the state law level and the criminal level, we can also see that police-specific laws and more generally applicable laws can provide two different layers of protection. Now, that's just Florida. It's not going to be exactly the same in every state.
Wow. Here's the thing. For me as a layman, I'm not sure who was about to come in there. It was Jerry. Jerry, you can come in a second, because I was just about to say, a lot of this just sounds like it's giving policemen license to murder. That's all it sounds like to me. But correct me if I'm wrong. Jerry, coming in.
The question I had is, it's even more complicated in that a lot of agencies, and I know from a federal standpoint, I don't know about the state agency, but officers are required by their policy most often to carry guns when they're off duty, and they're required to intervene in a crime. If it's a violent crime or a felony in their presence, they're required to take action. So that also provides an additional layer of protection in that their agency requires them to respond if they see a crime. Now, I don't know how that, I know how that works federally because you've got jurisdiction within the United States border. I don't know how that works from state to state. If for instance, in Idaho, my agency said, okay, if you see a felony, you're to be armed off duty because you're an officer all the time. And if you notice a felony occurring, you're obligated to take action. And I take that action, then I believe I would be protected under qualified immunity. However, if I'm in a neighboring state and I do that, I don't know that that would extend. And that would be my question for Seth.
Yeah, great question, and you're exactly right. At the local level, I think it's a little bit less common for agencies to require officers to carry, but I am not aware of any agency that prohibits its officers from carrying off-duty. Most of the policies that I'm aware of, and keep in mind there are 15,000 city and county police agencies, so I am not intimately familiar with all of them. Most of the policies that I'm aware of say that if an officer is carrying off-duty, they should also carry their police credentials and be prepared to take action as appropriate in the event that they see a crime or violent crime. So when and where officers can act is essentially a matter of state law, at least for state and local officers, city and county officers. It is a matter of state law. Typically, officers have limited jurisdiction. So a city officer may only be allowed to act within their city limits. A county officer may only generally be allowed to act within the county. But state law almost always recognizes statewide authority for officers under certain situations. So, for example, if a city officer is not in his city, if he's in a neighboring city or a neighboring county, and he sees a felony and acts as an officer, that will almost always be authorized as a matter of state law. We don't want to encourage the officer to make traffic stops out of their jurisdiction, but we want to allow the officer to take appropriate action when the situation demands it, essentially.
Okay. Just a very quick question, because we're going to have a whole more pile of questions that are still left, and I want to bring in Scott Russian, who's been waiting patiently in the wings. I also want to bring in Yolanda and Patrick, who's also sitting, and we're already half an hour before we finish. It's amazing how quickly time goes when not so much you're having fun. Quick question from TG. Can a citizen, I mean, she's still messaging, so so as a citizen, can I make a civil citizen's arrest at what I think is a wrongdoing? Does that make sense?
Yes, it does. Great question. That's also going to be governed by state law. Most states do allow some form of citizen's arrest, but you have to be exceptionally careful about it because the defense in state law, the what's called the defense of good faith and probable cause, that applies to police officers does not apply to civilians. So if an officer makes an arrest because he thinks someone committed a crime and then he ends up being wrong about that person committing a crime, so long as the officer had probable cause, they can't be sued. That is not true for citizens' arrests. If a civilian, if a community member makes an arrest because they think someone committed a crime and they are wrong, then they can be sued and they can also be criminally sanctioned. Wow. Don't forget, if you're making an arrest, if you jump on someone and hold them down, that's a battery. And if you move them from one place to another, that's a kidnapping. So you have to be exceptionally careful with citizens' arrests, but most states do still have a doctrine, a citizens' arrest doctrine on the books, yes.
That's just blown me away, and I think it's blown TJ away as well. Scott was was really instrumental in bringing this show together. And I know he's got some questions that he wants to bring into the arena. So I want to bring in Scott now, if I quickly can. Come in, Scott.
Can you hear me okay?
Absolutely, absolutely.
Seth, I've been taking notes, and I'm just looking. I have 7 notes already, but I won't bore you with that.
By the way, Scott, we need a 4-hour show for this. I think we need a part 2 already.
Just for me, I guess. Yeah. And I don't want to bloviate, and I told Seth he can cut me off. But I guess listening to all this and things like, a prior case must be established in order for, let's say, a new use of force case to move forward. Boy, what a burden on the attorneys, for the families to find prior legal precedent. But I guess that's not my question. Indirectly, Seth, when you're talking to your students and when you're out speaking in public, I guess what advice would you give to someone like the Phillips family, the Rushing family, D. Martin, Yolanda, McNair, the people you're talking to here that have lost loved ones to police officers? And of course, we feel it was unnecessary use of lethal force, unreasonable use of lethal force, etc. The terminology. I mean, what do we do? What advice as a professor, as a father, as an
expert,
as a student? What advice would you give someone like us? Now, we now know, just from listening to you, the obstacles. It's a minefield, the obstacles to families. So given that overarching theme that you've shared with us, what does a family do in our situation? What advice would you give us?
Yeah, that's a very difficult set of questions there. So I'm gonna divide my answer up in a couple of ways. First, there is a non-legal portion to that answer, and just sort of a let's see. I think I have 3 different answers to that. One is health focused, and that's make sure that you are talking to and working with mental health professionals. The type of incident, as you know, unfortunately, as all of you know far better than I do, and much to your detriment, the impacts of losing a loved one at all, but particularly to violence, and especially to police violence, are far-reaching and traumatic. You already talked earlier, Scott, when we were talking about it, you were talking about the way it can really damage families, can break families apart in ways that you wouldn't necessarily expect. I think it's exceptionally important to maintain as much of your own mental health and well-being as you can, because trauma lends itself to trauma. So I think one is just supporting yourself and each other to the extent that you can. Outside of the sort of health focus, I think there's a legal portion of that answer, and then there's a political portion of that answer. The legal portion of the answer is you need really to navigate this area, you need an attorney. I'm a little reluctant to say that, to be honest, because I don't want to come across like I am just protecting my profession here. I'm not trying to advertise for attorneys generally, but this is a very complicated area of law, and it's one that has a lot of factors to it. There is a state law component, there's a federal law component. It can be difficult. So I would look for an attorney, but I would also, and this is very difficult, particularly when you are in grief, you have to be very discriminating about selecting your attorney. Because this is such a complicated area of law, it is not one that every attorney specializes in. There are, in any given location, there are probably relatively few attorneys who really make this type of litigation a large part of their practice. And you want someone ideally who is experienced in this area of law. Not just someone who can learn about it. Any good attorney can learn a new area of law and can get up to speed. You want someone who really knows the process, who knows the law, who knows the wrinkles, who knows the complications.
In fact, sorry about that, Seth. Just before you carry on, when we had a round table, and I think it was about a year, maybe even 2 years ago, with Jonathan Newton, who is now, although he was a former law enforcement officer, he is now a qualified law attorney. One of the points that he made back then was that a lot of people are losing cases because they hire the wrong type of attorneys. They hire attorneys that are not experienced enough and knowledgeable enough in a police brutality or an unlawful killing environment, and are not prepared to or not as well informed to defend those that are, and that seems to be a real problem across board. So even in that respect, where do you find these experienced, knowledgeable, within your budget type of experienced experts of law enforcement, unlawful killing, police brutality style attorneys that are able to assist you in your battle when you're dealing with an issue like this?
And Seth, excuse me, let me piggyback on Kervin's question a bit. In my case, I, for example, was looking for an attorney after my son was killed, for the reasons everybody has stated. And there was no, let's say, directory. There was no resource. I called like the ACLU. I called, defense attorneys that you see advertised in the phone books, or we were actually going to be prosecuting. I'm a plaintiff. So, but there is no single authority in California, certainly not nationwide, where people can seek out attorneys to interview that will take their case, whether it's a contingency or, a private pay. We didn't talk about that, but I mean, it sounds good. Pick an attorney, be careful, interview them. I agree with that. But where do you go, Seth? There's no directory. You can't go online and Google, defense attorneys in my area, Yelp, Seth, that just doesn't exist. So, I mean, that's one of the reasons I reached out to you, because you're a professor of these young people, for the most part, men and women, who obviously are interested in a legal career. I mean, is there a mood amongst these students for, civil rights, for social justice? Are they willing to go down this road of defending, say, families who have lost loved ones, versus going another way? I call it the dark side, going towards, the easy road of defending government employees.
You mean easy money, right, Scott? Just say it. You mean easy money? Those guys.
It's not easy money to be a trial attorney. It's not easy money to take on the government police. You know that, Seth. And these students are learning that from you. So, but where does a person go? Is that something we could do as a roundtable? Start talking about getting attorneys together in Tampa or Raleigh or Boston or Topeka or LA, and start trying to create a directory so families have a resource, a place to go.
Yeah, I think that would be a very useful resource. My general answer, and I get a number of emails just by virtue of working at a law school of folks who are looking for an attorney. Most states have what's called a lawyer referral service or a certified lawyer referral service. they're not going to help you identify the best lawyers, but they are going to help you identify the lawyers who work in that area, so they can help narrow the pool at least a little bit. It may be better than just opening up to the extent that anyone has yellow pages anymore, than opening up the phone book and looking under attorney. The better approach, though, and this is not always helpful, the better approach is to look at, or at least one better approach is to look at news articles. Look for police shooting cases, and they don't have to be in your state. Look to see what attorneys are interacting with clients or being retained by clients in some of the high-profile cases. Now, that's not going to be perfect. Sometimes an attorney who really doesn't know the area will stumble into a high-profile case. But it at least can be a start, because a lot of the attorneys who work in this area, and particularly the ones who work on high-profile cases, they are repeat players. They're taking multiple cases, and they're developing a specialty in this. A lot of them practice or do work in multiple states. So I don't want to get distracted by talking about bar rules and ethics rules, but if you're in California and you really like an attorney or you keep reading about this attorney who represented a family in Ohio, it is perfectly ethical for you to call and consult and have a conversation with that attorney. And if they are available to take the case, and if you want them to take the case, they can work with local counsel. Essentially, the attorney that you've retained will be doing most of the work, but will be working cooperatively with an attorney in your state to help overcome the fact that they aren't a licensed attorney in the state that you live in.
Sure. I agree with that. I just know that, for example, I call like Jerry Spence's firm. They're in Montana or someplace. And when my son was killed, and they were very polite, but said, no, like, heck no, we're not taking your case. And I probably talked to 10 attorneys personally, and it's difficult. Each conversation is gut-wrenching for me to share the details of my son's killing. But I probably did it 10 times, and I had a couple attorneys interested. But I got turned down at least 8 times before I got my counsel, and I've been working with my counsel. So it's just another high bar set out there, to find the right attorney to, when you're numb, too, as you said, this, you're a dad. I mean, you're numb when this happens to you.
Okay, listen.
We are. It's an incredibly high bar.
Yeah, we are running.
I'm sorry.
We are running.
I'll shut up.
Yeah, we're running close to time, and we've still got Patrick and Dee and Yolanda who have still yet to come in. Yolanda is waiting in the wings, desperate for a comment and a question. Go ahead, Yolanda.
Kervin, I'm sorry to interrupt, Yolanda. Kervin, can I just add very, very briefly one last point there on? Okay, so as you're talking to attorneys, and I totally agree with you, Scott. There is no way that I can reduce the challenge and the secondary trauma of having to go over these things again and again. As you're talking with attorneys, it helps to have, or it helps to ask the attorney sort of what the long-term plan is, what the goal is. If the attorney is asking for money up front, that might be a sign that it's time to keep looking for an attorney. If an attorney tells you that the only thing that they are interested in is getting as much money for the claim as possible, and you are also interested in, for example, pushing the agency to change its policies, I guess what I'm saying is make sure that the attorney's goals and interests align with yours. The attorney is supposed to be your agent, but make sure that you are in agreement with their sort of focus. And I apologize for cutting Yolanda off.
That's fine, because that's a very significant point, because sometimes people could be easily swayed by an attorney that comes in who's charismatic, will come in and say, well, I can get you this, I can do this, we can go here, we can do that. And that might be totally a different line to where you was heading, but your desperation to get some form of justice could be discolored by a charismatic attorney who has his own agenda, so to speak, which is totally different to the one that you set off looking for. So it's important that people try to really affiliate themselves with somebody who's aligned with the same objectives that they have initially, as opposed to somebody that's looking to shift them from one arena to a whole different arena based on, because that's also down to their ability or inability to be able to get what the client is looking for, that they think they can get something else, and that might not necessarily be what the client wants, needs, or should be looking for. Is that not correct?
That's exactly right.
Okay, let's bring in Yolanda very quickly. We're going to try and move on as best we can, because we're down to 15 minutes.
Okay.
15 minutes and counting.
Yeah, I'll be real quick. I'm going to go in reverse order simply because you're talking about finding an attorney. My family and I, we were victimized by one because we didn't know that attorneys didn't know that there were certain rules for police officers that are different from governing the rest of the citizens. And that's a plight for us simply because we are on the clock from the beginning of our loved one being killed and us deciding to fight. The clock is ticking on us. So do you agree that it should be a change in the law that allow families to deal with the initial shock of losing their loved one before they have to go out and try to vet an attorney to start their fight against the police?
Yeah, so this is a question about what's called the statute of limitations. How long do you have before you must file a lawsuit, which, as far as I understand, I think is for 1983 lawsuits, for federal lawsuits, I believe it's 2 years everywhere. I hope someone corrects me if I am wrong about that.
Yes.
I haven't given a lot of thought to whether that should be extended or not. I can certainly see some potential because the family's first stop is not to the attorney's office. I think it is unrealistic to expect that a family's first stop is to an attorney's office and the family will be able to efficiently and quickly provide the attorney with all of the information they need. Whether 2 years is an insufficient amount of time is honestly not something that I've given enough thought to, and I would welcome your input, everyone on the panel, as having been in the situation in a way that I have not, as to whether that is sufficient.
Absolutely not efficient all the time. Another thing, as far as attorneys go, most of the attorneys that we end up with don't have a clue about police law, and we need to get a special training for them in order for them to be able to take our case. I think that is unfair, and that is a shyster move for us to be taken on by an attorney who doesn't know jack shit about what he's doing. And I'm just going to say it like that because that's the truth. Mm-hmm. The attorney that I had, he had his own motives in the end. He wanted to get a TV show. He wanted to get my daughter's case out in L.A., and us to sign off and let somebody else decide whether or not this cop was guilty of murdering her. I don't want to go to L.A. My daughter was killed in Detroit. Yeah. And as you're reasonable, I'm gonna do it together, Kervin, because I know we're out of time. As far as the reasonable in use of law, as far as officers' perception of his danger that he may be in, to me that is a get out of free card for being stuck on stupid and standing on dumb. Because any layman person can see the situation that the officer is in and see where the officer's life is not in danger or anything like that, as in Tennessee versus Garner, and this still be used. You are allowing people to be murdered over property. And in most cases, the property is already insured. So So it doesn't work for me, and that's one of the laws that I want to get changed as well.
You know, the unfortunate thing is, and yeah, I see exactly where Yolanda's coming from again. It's something that we continuously discuss on the round table, and not just on the round table, with most of the victims' families that we interview on this show, is the clear margins which not just suggest, right? They don't just insinuate, they prove beyond a shadow of a doubt that the officer had no need, there was no need to fire his weapon, let alone to kill an individual, and yet they still get this qualified immunity, which appears, based on your descriptions, a closed shop unit where a couple of friends get together over a pint of beer. And I know that's not how it happens. It may well happen in a legalized room somewhere. But as far as we're concerned, because we're not party to this conversation, debate, discussion, ruling that's taking place, right? It may well have been, a couple of guys sat around a table with a glass of beer and go, what do you think? Yeah, what do you think? Yeah, qualified immunity. Okay, no worries. Case closed. Because for the families that are fighting for justice, to have that door slammed in their face without even an explanation as to why qualified immunity was deemed necessary in this case, right, is a real travesty and a deflection of duty, a neglection of duty, right? And in itself, a breach of our civil rights, is it not?
Yeah, great questions. I'm going to take them in order. Within law, to Yolanda's point about attorneys really not knowing what they're doing, once attorneys graduate law school and pass the bar in their state and are admitted to practice, they are, so far as the legal profession is concerned, they can practice. They can do almost anything, right? They can practice in almost any area. They can take almost any kind of case. The only question is who's going to hire them. There are, in a number of states, what are called certified legal specialties that require special training or certain experience before a lawyer can hold themselves out as a certified legal specialist in an area. Unfortunately, in most states, civil rights is not an area of certified legal specialty. And one change to consider advocating for within the legal profession itself is establishing civil rights litigation, both as a plaintiff's attorney and as a defense attorney, establishing civil rights litigation as an area of certified legal specialty. So at least there is some minimum guarantee that an attorney knows some of the nuanced laws that they need to be aware of. As far as your point, Kervin, qualified immunity, at least in the policing context, in my opinion, has passed the point where it is justified and has become a problem. I am certainly not the only one to think that. I imagine that most of the panel here thinks that. The Cato Institute, a libertarian think tank here in the United States, has advocated for the elimination or dramatic reduction of qualified immunity for precisely the same reasons that you gave. It has become so protective as a doctrine that it sacrifices civil rights at the altar of protecting government officials from liability. And that is not the way, in my opinion, that laws in a democracy are supposed to work. We're supposed to protect, privilege, and prioritize civil rights above and beyond the protection for government actors. Now, I do think government actors need some form of protection. I do not think that it is appropriate to hold them strictly liable for all errors, but I think qualified immunity has extended past its point of usefulness. There's another legal scholar, Will Bode, B-A-U-D, who wrote an excellent academic article called "Is Qualified Immunity Unlawful?" I believe. And he lays out the Supreme Court's 3 justifications for qualified immunity, a historical argument and 2 policy arguments, and essentially demonstrates, to my mind, quite convincingly, why none of them actually support the doctrine as it currently exists. So while I think we have to respect the fact that the men and women in policing are human, they are going to make some number of mistakes, they're going to make reasonable mistakes. I think that qualified immunity provides protection to sometimes even the plainly incompetent or those who knowingly don't follow the law, and that's unacceptable in a free society.
Wow. We're down to our last 5 minutes, and we've not given Patrick Lane an opportunity to say a word. Patrick, I am deeply apologetic, but is there a question in all of this that you've been listening to that you might want to ask before we finally finish up?
Kervin, there's no need to apologize. This has been a most riveting and fascinating conversation. I'm so thankful for Professor Seth being here with us today, and Jerry, and all of us, and Jerry Summers also. I'm glad that we talked about precedent, and that any challenges to qualified immunity are required to provide these not specific precedents, but very similar precedents to challenge those rulings. And I'd like to hear, and we also talked about, and we've talked about around the round table before, laws and versus departmental policies and regulations and protocol that might exist. What are my question to both the professor and to Jerry is, what are your feelings about laws that we need to put on the books that would more clearly govern qualified immunity rulings, and how do those stack up against any departmental policies and regulations that police departments might put into place? But I want to say that to the professors that I want to plug your book, Evaluating Police's Uses of Force, is a book that I plan to get my hands on. I can't wait to delve into that. So thank you very much for being here. And my question really was about the laws versus, if you could real quickly, laws that are needed to more closely govern qualified immunity versus what we see some departments are just putting policies into place or speaking of policies and regulations that they will be adding. If you could speak to that very briefly, I'd appreciate it. Thank you.
Sure. So first thing to point out is an agency policy does not establish legal rights. So an agency can adopt a policy that's an excellent policy that's very appropriately restrictive on the use of deadly force. And if an officer violates that policy, they still might not be able to get sued or criminally prosecuted. At best, they can be administratively disciplined, potentially terminated for not following the employer's rules. So I think that agency policies are incredibly important. I don't think they are sufficient. When it comes to laws at the federal level, Congress could pass a law that eliminates or restricts qualified immunity. I don't have a lot of hope for that happening, but I think it is something that probably should happen. I think one area that we don't focus as much in as we should are state laws, because when an officer is sued in state court for a state claim, a state tort claim, the doctrine of qualified immunity that we've been discussing doesn't apply. States often have some type of equivalence to qualified immunity, but it can be far easier to change the state law standards for use of force and for official immunity than it is to change the federal and constitutional standard. So as far as types of laws, I would look at some of the recent laws. I think California recently passed Assembly Bill 932, which I, again, for full disclosure, I helped work on around the edges. Washington has a good state use of force law. If that is clear enough, it can be written in a way that also addresses police immunities to criminal and civil liability. But I know Jerry may also have a lot of wisdom to share here.
Yeah, I'd like to jump in. Really, from my perspective, I agree with what Seth has said, but I'd also like to see a federal law that deals with transparency within police discipline. I understand that there's a certain amount of public information, private information that has to be protected, but once an investigation is done, it should be open to the public to review all documents that do not disclose personal, Social Security, that kind of thing, or a summary should be done where the agency head needs to summarize what the action occurred, what the results of the finding of the investigations were, and what action they took. The problem we're seeing is that a lot of, and this goes right to the culture of law enforcement, since they can bury something under an investigation currently under process, or they don't have to disclose it, we don't get to see what the agency heads are doing. And one of the biggest problems I had as the chief of police when I disciplined or fired an officer for ethical or a legal violation, I could not then come out and say why I did that. All I could simply say is that they were removed. And I think I'd like to see a law established where if an individual, a government official, receives 50% or more of their funds from taxpayer money, then their personnel records should be open to the public for investigation with the appropriate amount of redaction. And I think that will change the culture within law enforcement.
Thank you very much. Thank you.
You know, gentlemen, I'm going to have to say this. I could carry this on all night. But we stopped streaming on the website about a minute ago, even though we're still streaming live on Facebook, Twitter, and YouTube. But as we are affiliated to the website, the World Jam Global Radio Network, we're going to have to bring this to an end at some point, and I think it's around about that time. I want to invite Professor Seth Stoughton to come back again. Me and TJ have been having a conversation in the background, and we do believe that there is so much more that we can still unpack on this if the professor will return. Which is something that we really would love to, schedule. But, all I can say is, and I do really want to say this in finishing up, this has been one of the most informative shows that we've ever had in the 6 years of doing this. And I couldn't think of a greater honor as a tribute to Linda Sue, who passed away, the originator. She named this show Issues Today, and created the template and the format for which we operate in, that myself and TJ have worked so hard in perfecting and getting you guys on board, supporting, that has created this family and platform for many people to come on here and tell and share their stories. I couldn't have found a better show to honor Linda Sue than the one that we've just done here today. So I want to thank every single one of you who's taken part in today's show. Jerry Summers, Scott Russian, Patrick Lane, D. Martin, Yolanda McNair, our very own TJ, Therese Gallagher, my producer, boss, and co-writer, and especially Professor Seth Stoughton. But again, maybe we'll have this conversation out of here. Please don't come off the line. We're going to come to the end of the show, but I think we're going to carry on with this conversation just for a couple of minutes afterwards as we find out whether Professor Stoughton will return or not. But it's I suppose it's a bit of sadness that I say that unfortunately all good things must come to an end. But it's the end of the show. So we're out of here. Thank you very much.